welcome to this channel. In this episode, we'll discuss the concept no fault liability. Hope you will enjoy this video. Please check the description box for more videos. Kindly like, share and subscribe the channel. Before entering into this subject, we must know how the liability arises. When one having a right, another corresponding to him having duty. When the act or omission of the second person causes harm or damages to the first person, there arises the concept of liability. But when there is no negligence, but the liability arises, such liability is called no fault liability. It is the antithesis of fault-based liability. No fault liability based on two concepts. One, strict liability, and two, absolute liability. Strict liability. The concept of strict liability developed in the 19th century in the English courts in Rowlands versus Fletcher, more particularly in 1868. In this case, Fletcher, the defendant, built a water reservoir in his land through the engineers. While constructing the water reservoir, the contractor neglected the mine shaft beneath the land. Rowland had the land adjoining to the plot of Fletcher. In that land, Rowland had mines. By constructing the water reservoir by Fletcher in his land and neglecting the mine shaft beneath the land, and the water flowed to the mines of Rowland from the land of Fletcher. Thus, the damage caused to Rowland's mines, and he sued Fletcher. Fletcher argued that engineers who constructed the water reservoir were independent contractors, so he does not owe the liability for the damages caused to Rowland. Court disagreed with the plea of Fletcher. Blackburn was the judge of this case, and he said, "We think that the rule of law is that the person who for his own bare purpose brings on his lands and keeps there anything likely to do mischief, if it escapes, must keep it in at his peril, and if he does not do so, is prima facie answerable for all the damage which is the natural consequence of its escape. He can excuse himself by showing that escape was owing to the plaintiff's default, or perhaps that escape was the consequence of vis major or the act of God. But as nothing of this sort exists here, it is unnecessary to inquire what excuse would be sufficient." Circumstances under which the application of strict liability comes into effect. 1. Dangerous item or thing brought by the owner on his land. 2. It must be unnatural use of land. 3. Such dangerous things brought or kept by the owner must escape. 4. Such damages caused must be under knowledge of the defendant. But there are some exceptions when the defendant is not accountable for the damages. 1. Act of God. 2. Plaintiff's own fault. 3. Consent of the plaintiff. 4. Act of the third party. 5. Statutory authority. With the passage of time, the change of legal approach towards the liability and the development of the industrialization, the concept of strict liability have turned into absolute liability. In India, the courts developed the concept of absolute liability in the m.c.Meheta case. Justice Bhagavati, while introducing the absolute liability, forwarded the following findings in his judgment. 1. The Indian courts did not bind itself in the English judgment of Rowlands versus Fletcher, as with the change of time and the advancement of the scientific knowledge and industrialization, the exceptions found in the rule of strict liability were struck down in the absolute liability. 2. If the dangerous items is dealt by the industry, then only the industry have the capacity to maintain the safety and control of the same. And if it escape and owing to which any harm is caused, then such industry will have the absolute liability. 3. When an enterprise is allowed to deal with the hazardous item of such nature, it is presumed that it is conditioned to meet the loss arising out of the harm inflicted. After the propounding of the rule of absolute liability in the m.c.Meheta case, the rule has been followed in other cases also. 1. Union Carbide Corporation versus Union of India, better known as Bhopal gas leak case of 1984. 2. Vizag gas leak case. No fault liability as introduced in England in the Reynolds versus Fletcher case in 1868 in the form of strict liability and turned into absolute liability in the Indian legal context through the m.c.Meheta case. As the advancement of the industrialization and the risk factors have been multiplied, the Indian courts took the more pragmatic approach with the advancement of time and other connected factors.